once the county court at law judge rules, then you will have, assuming it is an unfavorable decision, 10 days in which to file a supersedious bond if you wish to stay in possession of the property and appeal to the Court of Appeals. You simply are going to be almost in a situation where this is impossible to do without an attorney, because you're now talking about trying to appeal to the Court of Appeals on an appellate record, and this is very difficult for lawyers, to say nothing about someone who is representing themselves. But it is important to know, if you are considering an appeal to the Court of Appeals and wish to stay in possession of the property, then you have to file a supersedious bond in the county court within 10 days of the date that the judge ruled against you in county court. If you do not file the supersedious bond within those 10 days after the county court judge rules, then the landlord may have the constable set you out. But you do have those 10 days in which to file that supersedious bond. Unfortunately, I find that oftentimes judges who don't regularly hear cases in this area are unfamiliar with the requirement of the Texas Property Code that gives tenants 10 days to file a supersedious bond. So this may require some education on your part of the judge. The judge gets to set the supersedious bond under certain guidelines. It is often a very expensive bond, and in most cases tenants simply cannot afford to pay that supersedious bond. But there are cases where it may be something that you can afford and you feel strongly enough that you wish to appeal to the Court of Appeals and remain in possession. And if so, you can remain in possession and appeal by paying a supersedious bond within 10 days after the county court judgment.